I'm here with Warren Margolies, partner at Grossberg, Yochelson, Fox, and Beyda. And Warren, you're somebody that I've been eager to connect with ever since the COVID virus forced companies to shut down their office and work remotely these past 2 weeks. I know personally I'm getting a lot of calls from tenants who are worried about their cash flow and looking to real estate, which, as you know, is one of their largest bottom line expenses, to see what options there are to cut costs. And I'm also working with a lot of tenants who are actively in lease negotiations or have recently signed leases where a full build out and relocation is scheduled to take place. So as a real estate attorney, you and I have done a lot of work together. I thought it'd be beneficial to pick your brain. There's a lot of people out there that can benefit from your insights, understanding in no way, shape, or form are you giving direct legal counsel to anybody watching. I think we should preface that, and I'll put your contact information in the LinkedIn page after this. But you can provide some insights on common concerns and questions that they may be experiencing with regards to their office space and lease. So before I go any further, tell us a little bit of who you about yourself and what you do.
Yeah, absolutely. So I've been doing commercial real estate law since '06. I graduated law school in '06 and have been doing it since then. I was in-house at a local DC developer for my formative years. And then I've been in private practice for about 5 years, almost exclusively leasing. I represent primarily tenants, office, retail, hospitality. So, I'm definitely in the weeds on this stuff, particularly the last couple of weeks. Yeah.
Well, just like no human's been immune to this virus, no business is immune to the effects either. But obviously that doesn't mean bills just stop or negotiations simply halt. And one of the major bills for every company is their lease liability on their office space. So starting with, let's start with tenants who are in occupancy and may have several years left on their lease, but are concerned about cash flow right now. And are tenants, I think I know the answer to this, but are tenants required to pay rent even though they are prevented or highly encouraged to not enter the workplace? And what provisions should they be looking for in their lease to understand what relief options they have, whether it's force majeure or disruption of services in that regard?
So a couple of points here. One, I guess I'll start with like the four corners of the lease document, because, I think everyone's first reaction when this hit in terms of, oh, I need to go look at my lease, I need to go figure out what my rights are here, was to go look at the force majeure provision. But the reality is that even if it was a heavily negotiated provision when you signed your lease, typically a landlord is going to carve out any financial obligations. And so it'll get you out of your non-monetary obligations, but that's not what you're concerned about right now at this present moment. You're concerned about figuring out how you're going to make your April 1st rent payment. And so force majeure is really not going to be of any help there, even if, to your point, you can't get in your space. You can't even get into the building because the landlord shut the building down. The one provision that you might want to look to is to your point, the interruption of services provision. Typically it'll say if you haven't been provided any base building services or access to your space for 5 business days, then commencing on the 6th business day, that you can start abating your rent payment, something to that effect. Typically, those provisions are limited to matters within a landlord's control, and obviously, COVID-19 wouldn't fall within that. But I've abstracted a lot of these in the last couple of weeks, and I think you do see a number of these provisions. It's not common, but you will see it on occasion, that aren't limited to matters within a landlord's control, and it'll say, anytime that you don't have access to the space for 5 days, then on business day number 6, rent can abate. So that would be the first place I would look. All that said, the reality is that I think anytime that you're going to a landlord and you're saying, look, like I went through my lease and I think pursuant to section 23.17 that I shouldn't be paying rent. So what can you do for me? I think that's obviously introducing this adversarial element to the conversation that, like, there's a lot of goodwill out there right now. I think everyone in the commercial real estate industry and everyone in the world is in the same boat right now, and we're all struggling. And I think if you reach out to your landlord and say, hey, I didn't really envision this scenario on March 1st, but here we are. And I've been in my space for 2.5 years. I've paid rent on time every month. You can go back and look at my track record. I've never been in default. I've been doing everything I'm supposed to. And, you know, I need 60 days to take this line item off my bill. I think that both parties will work together to get creative. And I think that's a way better way to approach this situation.
I think that's really sound advice, and along the lines that I've been advising my tenants, where I think the best order of communication should be reaching out to the landlord directly while also being aware of what's in your lease document, but principal to principal, from tenant to landlord, letting them know as detailed as possible the troubles and the circumstances that you anticipate encountering as it relates to your lease document, and asking them how they would suggest you proceed, and getting out ahead of that early. Clearly, it's in the landlord's best interest to address this, what is hopefully temporary, periodic trouble, rather than put your ability to fulfill the remainder of your lease liability in jeopardy because they won't work with you at this particular moment.
I mean, by all means, keep those lease rights in your back pocket. But I would certainly start off with the good-natured approach. And, you know, if you've been paying rent, the reality is the landlord's going to want you in the building for the rest of your term. It's just a matter of sort of bridging that gap to the other side of this insanity. And so, yeah, I think dialogue, communication, reach out to them now. Don't, you know, on April 1st to say, you know, I'm not going to pay rent and I'll see what their reaction is. Get out ahead of this on the front end.
So what about tenants who are at the end of their lease cycles and they've either just signed a lease or about to sign a lease that requires a full build out and relocation? What are some of the considerations they should be taking?
The biggest thing is whoever is managing that initial build out of the new space, I think construction uncertainty is the most tangible, or one of the most tangible ways that this whole situation is going to affect a new lease. And if a tenant is taking space and it's just the landlord managing the initial build out, you know, that helps in one sense, because your commencement date probably isn't going to occur until the landlord actually delivers the space, and that could get pushed back a few months. But at the same time, you're not going to be, you know, stuck paying rent on a space that you haven't taken occupancy of yet.
If their lease expiration is
Right.
approaching and the landlord is still controlling that process, or they're controlling that process, clearly the landlord wants to get them in as early as possible. But if they're unable to hit those deadlines and that tenant is faced with a holdover provision in their existing lease, have you seen landlords working with tenants willing to absorb those holdover penalties in order to retain their tenancy and commit to the build out and getting them in as early as reasonably possible?
Yeah, absolutely. I've seen that a decent amount. And then I've also seen, the other thing is, you know, if the landlord has space in that new building, they can offer them temporary swing space for a couple months at a time, just getting creative to bridge that gap. Because, yeah, I mean, to the extent that there was a possibility of that gap, that possibility increased greatly in the last couple of weeks. And so, yeah, it's you know, I think it's a matter of reaching out to the landlord and saying everything is going to get pushed back a few months. So how am I going to account for that gap?
So last night, the Senate just passed a $2.2 trillion stimulus package that includes $367 billion employee retention fund. Should this provide comfort to companies who are faced with making difficult cuts, that they can feel better about making their monthly rent payments since there's now a fund to address employee salaries? I know it's early, you're probably still getting your arms around it, but what's your early take on how this stimulus package may impact real estate?
Well, the one idea that I discussed this morning that I think makes a lot of sense is, you know, to the extent that a tenant is going to apply for an SBA loan, which is part of this stimulus package, that and while they're applying for this SBA loan, they're also asking a landlord for 60 days, 90 days, however much of rent abatement. You can get creative with the landlord and you know, say that you'll collaterally assign the proceeds of this SBA loan, because obviously I think the landlord's concern at that point is, well, you're taking this loan money, and meanwhile you're asking to abate rent for 60 or 90 days. And I think it's part of the larger conversation too, that when the landlord does grant this rent abatement, they want to know the structure of what it's going to look like, and they want to know how they're going to get paid back, and they want to make sure they actually are going to get paid back. So to the extent that you can provide evidence that you're getting this SBA loan as part of the stimulus package, I think that's an easy way to ease some of the landlord's concern.
That's an interesting perspective I actually hadn't considered in terms of leveraging the SBA loan as part of providing the entirety of the package to the landlord to show why the rent relief, and they'll be made whole in the back end. Now there's a lot of tenants out there who also lease their space to subtenants, third-party subtenants, and find themselves with their landlord hats on. And just like the tenants themselves are looking to the direct landlord for relief, some of their subtenants, which could be a substantial part of their revenue, are looking for relief as well. What are some of the risks a sub-landlord may encounter and some of the considerations to address them?
It's the same thing. And I think ultimately, if a landlord gives a tenant rent abatement, then it's only fair for that tenant to then pass through the proportionate share of that rent abatement onto the subtenant. But at the same time, if they're not going to get rent abatement, I don't see how. I think everything sort of has to be dictated by what's in the master lease, what's going to happen between the prime landlord and the prime tenant. As you said, they're, while on one hand they're asking their landlord for rent abatement, on the other hand they're putting their own landlord hat on, so they're stuck squarely in the middle there. But I think it's only fair to, you can't have one without the other.
So are there any other common requests or questions or concerns that you've been encountering these last couple of weeks on behalf of tenants or landlords? And do you think this will impact how people view real estate lease agreements going into the future?
Well, it's funny, is I've spent years and years saying that I think my job as a real estate attorney is to make sure that like that 1% possibility or 0.1% or whatever we're going to call it is accounted for in the contract, right? So like, I always say that like, I would love if I negotiate a lease on behalf of my client and we never speak again until that lease expires 10 years from now, and you've paid your rent every month and the landlord did everything they were supposed to. But like, if something happens, if those services go out, if something crazy happens, like, let's prepare for that on the front end. So on the one hand, it does give a little more credence to that. I think that like, hey, sometimes really crazy things do happen over the course of this 10-year lease term. So that's how I'm thinking of it from a legal perspective. The one other point I would make on construction delays for tenants entering into new leases is if they're managing their own build out, I would explicitly negotiate into the work letter that we don't know what the nature of these delays are going to look like. And to the extent that there's a fixed commencement date where everyone was anticipating when this letter of intent got signed a few weeks ago that the tenant was going to start paying rent on September 1st because they needed 3 months to build out the space, and that was going to all start on June 1st. Those dates may very well slide due to this, and we don't know the extent of it. And so I do think you'd want very, very specific language in that work letter saying, look, that September 1st date needs to get delayed day for day to the extent that we can't perform any of our anticipated construction work. Yeah.
No, all good insights. We might have to do a part 2 of this, and hopefully not a part 3 and 4, depending on how long this goes on. But you covered a lot of information, a lot of questions that I'm sure they will continue to unfold as this proceeds. So I hope you and the family stay safe, and let's do this again soon. And as new questions start to emerge on my end, you'll certainly be one I reach out to pick your brain. So thanks, Warren. I really appreciate it.
No worries. Happy to help.
All right. Stay safe, buddy.